studies, people have approached this from a different and often non-state perspective. So, for example, while Hagop argues that the Sharia is an ethical and moral system in which offenses are violations of God's law rather than that of the state. Seeing law and morality on a continuum, Muhammad Kamali views acts as falling on a spectrum of obligatory, recommended, permitted, reprehensible, and prohibited within the Sharia. And it's only the obligatory and prohibited acts that fall within the purview of law because they are subject to sanction, while the remaining three categories are moral because they don't. Recent studies by Roy Mutahide, Michael Cook, Kristen Stilt, Barbara Johansson, Sara, and Ahmed El-Shamsi, so a lot of people coming from Islamic legal studies, have instead viewed the legal or moral status of an act as dependent on its public or private character. And so it's really inspired by these studies that have applied many of their insights to understand 19th century Iran. In my book, I typically use public and private, I don't use public and private as direct translations from any single Persian or Arabic term, but as categories describing related concepts, practices, and principles. I, for example, do not use public to refer to the Habermasian public sphere or to state-owned or commonly owned property. I also avoid using public law to refer to individual state relations in tax, criminal, or constitutional matters. Nor do I use private to mean individually owned property. Instead, I aim to use public to mean acts which are manifest and often described as debased and profane, while private encompasses acts which are secret, sacred, and inviolable. This distinction is crucial to understanding why certain acts were considered punishable crimes. So building on this framework, I examine how this public-private distinction affects things like policing, rules of evidence, and punishment. In Qajar Iran, the Islamic concept of commanding good and forbidding wrong, after the ma'ruf and nahy as munkar, was often deployed as a justification for moral policing, as it is today. The basis of moral policing was the nature of the act. Public illicit acts were subject to it, while illicit acts occurring in private were not. The rules of evidence similarly had a public dimension to them. Conviction, whether on the basis of Islamic law or government law, typically required either confession or eyewitness testimony and an oath procedure in the case of an intentional homicide. In cases where evidence was circumstantial and the act was in a sense private, the state relied on an often effective mechanism of publicizing the secret sin, namely judicial torture. Finally, punishments were almost always public because crime harmed and affected the entire community and or injured the sovereign. Public punishments function not only as deterrent lessons or ibrat, but also as forms of shaming. So this is in the case of punitive parades, which I say a lot about in the book. Public bodily marks, and this is true in the case of branding and haircutting punishments, and I've written articles on both of those forms of punishment, or the containment of public harm through mechanisms like imprisonment. So I'll leave it there, and we can continue with our conversation.
Okay, thank you very much. Is this on?
Yeah.
It is on, okay. So maybe I'm gonna say sort of just a few sentences about kind of how I, sort of the important themes that jumped out for me, obviously, which shaped by my interest in the book. But feel free, obviously, to correct me if I have things wrong, and then I have some questions, but you actually kind of answered my first two questions, maybe, sort of about how you came to the book, and then, well, I'm sure there's more to say about sources. But no, this is a really fascinating and compelling book. It's an amazing achievement. And so I want to, just to quote the introduction on sort of a most basic level, the book is a socio-legal history of crime, policing, and punishment in 19th century Iran. And based on incredibly rich archival research, it uses the relationship between concepts and practices approximately translated into English as public and private to explore questions around sovereignty, jurisdiction, law, and violence. So in some ways, some of us, might see some aspects of a familiar process that is often called legal modernization. This is sort of one of my questions, actually. The increasing formalization, systemization, territorialization, homogenization of law, and the ways in which that process replaced a system of multiple sovereignties, jurisdictions, laws, courts, and policing systems, or a system in which those interrelated, right? Not contended, right? So I understand one of the arguments is that they weren't just, these different systems weren't just contending in this kind of chaotic pre-modern way, or an instance of like Iran's failed modernization of something in the 19th century, which I think is one of the interventions here in the scholarship on Iran, but that they interrelated in a coherent way, right? Even though they were multiple and pluralistic. So in other ways, it contests a simple story of modernization, showing ongoing contestations over law and sovereignty. So I think this is another part, not just sort of how we think about this process in the 19th century, but also maybe sort of going forward, and the epilogue kind of points forward also. Ongoing contestations over law and sovereignty around particular Iranian concepts, practice, and spaces, described in one place in the book as Iran's local modes of lawcraft that continue to shape the later history. So I think that's another way in which it kind of contests a modernization narrative, not just how we understand this multiplicity in the 19th century, but also kind of how we understand continuation of some of these, continuation and transformation of some of these local modes of lawcraft that continue to shape the later history. Constitutional Revolution, the Pahlavi era, and the 1979 Islamic Revolution, which are all mentioned in the epilogue. So for me, the book's really close attention to these local modes of lawcraft is one of the really impressive and compelling, and for me, really, really interesting aspects of it. So feel free to comment on any of that, but I also, I was going to ask sort of how you came to the book, which you described, but if you want to add anything, were there any sort of archival moments, sort of aha moments or epiphanies when you were in the archives that sort of come to you that you didn't already cover, if you might want to tell us about?
Yeah, no, thank you. Well, one thing that happened is that in, I would say, 2022, I had a draft of the entire book, and what changed, or actually no, it must have been, yes, I had the draft maybe a little bit earlier than that even, probably around 2020, sorry. COVID-19 happened, and one of the major archives, the Sazman Asnad, decided that they would make everything available online. So as long as you had a password and a username, you could access a lot of this material remotely. So then as I went through the material that was available on the Sazman Asnad, and other researchers who had gone there had noted that it's difficult to get sources and exactly what you want. They would kind of make it difficult for you, but this was just open access. So I spent 2 summers with a research assistant essentially downloading a ton of archival materials, which really forced me to reshape some of these chapters that I had already written. So that was definitely a big archival moment, and actually my research assistant had very good contacts in Iran, and she was able to get me a source called the Jami Nasiri, which is a Islamic legal compendium that was commissioned at the behest of Nasruddin Shah. And this was housed in the Gulistan Palace, which was in the news these days because it's been bombed, unfortunately. And this was also an incredible source because it was an Islamic legal compendium, which you would typically think of as something within the genre of Islamic jurisprudence, but it was written by the Shah. It was commissioned by the Shah, and the intention for it was that it would be used as an administrative manual. So it would be a kind of a form of Islamic jurisprudence that was not just theoretical, but would be applied as law. And part of what was an aha moment, and kind of I bring up in the epilogue with respect to that source, for example, is that it's the first time the chapter on hudud we can think of as an attempt to talk about Islamic jurisprudence as law, as qanun, because it is referred to as a qanun shariat, or which kind of flies in the face in some of the Islamic legal literature that tends to treat qanun as something very separate, in earlier periods maybe connected to the qanun nomes of the Ottoman Empire, and in later periods as kind of a Western modern concept or what have you. So there's ways in which I think processes, and this is what you alluded to as well, that are grounded in the 19th century inform and anticipate maybe some of the configurations that we see in the 20th.
Thank you. So as I mentioned, and I mentioned that one of the things that was really interesting to me is your attention to what you call Iran's local modes of lawcraft, or elsewhere vernacular legal systems. And you make an argument that formal institutions were less vital than practices in 19th century Iran. not the what but the how is another way to put it. So I wonder if you could elaborate on that a bit, which it sounds like both a kind of thematic and a methodological intervention, kind of the scholarship on law in the 19th century.
Yeah, so that's a great question. So one of my frustrations with kind of maybe some of the scholarship on legal modernization is that you can only deal with certain themes once the institution is visible, right? So you need to have modern prisons to really talk about the history of the prison, for example. You need to have a modern court system with lawyers and judges and what have you to talk about jurisprudence and courts and what have you. Or a modern police force in order to talk about policing. And what I tried to do was to look at the processes, as you pointed out, and look at where you would have policing occur. Because obviously you did have policing, obviously you did have imprisonment, and obviously you did have trials and some sort of court practices in place. But they don't graft onto our contemporary and Western notions of what they should look like. Another aspect of that process that I tried to examine was how the state embedded itself within social processes. So one theme that comes up in many different chapters, for example, is the whole concept of guarantorship, of zimanatname or iltizams. And what the state did is it tried to create these interlocking systems by which people were responsible for those under them, for kind of policing those that were under them. And it was a way to make up for the fact that it wasn't a modern state with a big institution, with a big budget for policing or what have you. And it was these interlocking relationships that allowed for, in a sense, the state to project power beyond its capacity in terms of formal, say, policing figures or what have you. So these are just some of the examples of how I try to look at process rather than institutions. And the other thing that I found is that a lot of these processes encompassed actors that were not from just one element of society. So it could include government officials, but it could also include the ulama, and it could also include religious seminaries and sayyids and what have you. So there's many different social actors that get involved in law, and in fact I would even argue that ordinary people had a claim and a sense in which they felt they were parties to enacting the law.
Yeah, that comes through really well, I think, in the process. On the one hand, it seemed to me like the focus on the processes kind of paradoxically allows us to see lots of different institutions in different ways, right? As they're interacting with each other, because you focus on all these different sort of, the police code, the military code, these different sort of administrative codes, in addition to the ones we're maybe more familiar with as historians, like, Islamic law and state law, right? Mm-hmm. But then we also see these institutions changing, right? Like the shrine sanctuaries kind of become prisons themselves, right? Yeah. Just because of sort of those changes in the 19th century. I'll come back to that. But I did want to, before we get too much into the weeds, or into the details of the weeds, talk about both something that both you and I mentioned in our introductory comments, which is this public-private framework that's in the title of the book, and in many ways this runs through all of the chapters, right? This relation between public and private in criminal law, policing, and punishment in 19th century Iran. So you say in the introduction, this is not, we shouldn't, and you said that here again too, that we can't understand these just in terms of the sort of standard ways we understand these in English. They're kind of approximate translations of a cluster of concepts and practices, right? In Qajar Iran. So one thing I was interested in related to that is, if you could tell us how this framework played out, in particular in this tradition of sanctuary, which I thought those sections were so interesting. And how the sanctuaries around shrines, but also they extended quite a bit beyond that, at least in the however much part of the century before that starts closing down. So it does, seems to cross what we might think of as public and private spaces, right? There's certainly public spaces within the shrine complexes and the shrines themselves, but then it extended out to the residences, right, of the shrine managers or custodians. They're private homes that we might call them. And part of what the government was trying to do, right, in the late part of the century was close that down, right? So it did not extend into the residences. So I wonder if you could just talk a little bit more about this, partly for people who haven't read the book, it's so interesting. And then, if you want to, give any further reflections on sort of how we think about these legal concepts of privacy in the 19th century.
Yeah, great. No, that's a good question. So a lot of what the whole notion of privacy revolves around is the notion of hormat, or sanctity, and that's also related to the concept of the domicile or the harem, right? So it's all from the same trilateral Arabic root in some ways. And the shrine itself is referred to as the haram, right? So there's ways in which all these concepts are really important for understanding local forms of privacy. And in fact, there is much of an emphasis in Islamic law about the inviolability of the home, right? Not being able to go into the home, or if someone is engaging in sinful behavior within the home, not being allowed to spy or punish them or what have you. And a lot of the same ideas or protections that the home has are also extended to the shrine. Initially, at least within Islamic jurisprudence, this really extended or was focused on Mecca and Medina, right? So there was this idea that you couldn't, for example, carry out the hudud or fixed mandatory punishments in the sanctuary, right? There are even instances of hadith that talk about, say, if a stray animal goes into the haram, you can't slaughter it, right? You have to wait for it to come out, and what have you. So there's this inviolability principle. And so what makes the shrine quite fascinating, and I think this is kind of what you're perhaps trying to point out, is that in some ways it blurs the boundaries because it is, in a sense, a public space. But it has the same inviolability associated with the private, with the domicile. And so in some ways, the way I see this as operating is that it's a check on the Qajar state's power. And it's a way in which there's a suspension of the law within this space, which is quite significant, and which creates the space for people to perhaps negotiate in cases where they might otherwise be subject to illegal or sort of unfair imprisonment or torture or even punishment.
Yeah, and there's a lot in the book about how this kind of the sanctuary concept and practice, that practices laws, attracts crime to the to the spaces of sanctity, right? So you get this kind of or criminals, right?
Yes, yeah. And I mean, the best example of that is in the shrine city of Qom, right? So we typically don't necessarily think of Qom as a major center of criminal activity, but a lot of the maybe we do. But many of the shrine servants, in fact, they ran prostitution rings out of their sanctuary zones, or they ran extortion rackets of pilgrims, and they could do it without getting punished. So part of what we see in the 19th century are governors like Adib al-Mulk, who tries to go in and rein all of this and tries to curtail these practices, which is interesting because in order to do this, he uses Islamic modes of reasoning, and he says, well, God's law is meant to be implemented. And what you're doing by protecting these criminals within the shrine zone is not allowing for God's law to be practiced. And the types of arguments that he's using is that, no, this is a shrine. It stands outside of all of these norms. And so, if we violate it, this is a major taboo, right, of the sanctuary principle. And so there's this back and forth having to do with shrines. And, as I was writing this, I was also thinking about the American political context, sanctuary cities, right? And so I think in some ways what's interesting about sanctuaries is that there's a recognition that the law is imperfect, right? And that the law can be unjust. And so in some ways, although oftentimes we celebrate this idea of legality and equality before the law and everyone being subject to the law, in practice, it can be actually the very opposite of what it claims to be when it comes to justice.
Yeah, that's really interesting. It was all really interesting for me, not to make this about me, but just really quickly that, because I'm working on Najaf in the late 19th century, long 19th century, so going up to World War I and through World War I. But Najaf, during World War I became this like sanctuary city. It was kind of considered a sanctuary city anyway, since all these deserters from the Ottoman army start going there, and then the whole town has a rebellion against the Ottoman army and kicks them out because they're protecting these deserters in the sanctuary space. So it helped me think about that kind of in new ways.
That's very interesting, because that was another thing that I had always wondered if anyone in the Ottoman context had worked on, because it is so prominent in Iranian history. This whole notion of the sanctuary. It seems, at least to me on the surface, it doesn't seem to play as big of a role in Ottoman history. Correct me if I'm wrong.
No, totally. Yeah.
And it's just something that in the 19th century you constantly see people taking sanctuary, not just at shrines, by the way, but also royal stables, telegraph offices, the homes of prominent notables. So there's a number of spaces that function as sanctuaries in the 19th century in Iran.
No, I heard about that much more with Iran than I had with Iraq or Ottoman Empire until I started looking into these sources for Iraq. Even Sunni soldiers would go to Najaf because it was the sanctuary city for deserters.
That's fascinating, yeah.
So let me see what this question is. So I have a question related to this. So I already mentioned this a little bit, but the multiplicity of jurisdictions, laws, ports, and spaces in the 19th century. You often actually just kind of gestured at this too. There's often this provided room for maneuver for ordinary Iranians, right? Especially those maybe suspected of or charged with crimes, but for others maybe also. If you want to give another example of that or two, that might be helpful for people to understand that argument. And then I'm also kind of wondering how you sort of see that this room for maneuver in relation to, the increasing territorialization, homogenization of law, right? Because you're contesting the legal modernization framework, right? I think one of the first sections in the introduction is beyond legal modernity and modernization. But we also have this increasing sort of shutting down of this room for maneuver, right? And so I just wondered, do you want to say anything more about that? Is that kind of a tension here that not a tension as a contradiction because you're looking at both things, but sort of how you think about that?
Yeah, so I think there was definitely attempts to shut it down, but what I think happened is that the attempts weren't necessarily all that effective. So at the level of norms, there was a desire to shut down these sanctuary spaces, but in terms of the actual reality and practice, you still have a lot of people using these sanctuaries. And what it does is when you have criminal cases, like in the cases of murder, for example, is that it leads to a jurisdictional tug of war between the shrine guardian. Sometimes the governor is also a major player in this, trying to assert their own positions. Sometimes they're on the side of the shrine guardian, sometimes they're on the side of the other pole of authority, which is the Shah and his court, right? So what will often happen is that you'll have three very different takes on what should be done with an accused murder. And the types of arguments that occur related to this are, well, if we drag the suspected person out of the shrine through violence, this is going to violate that principle of inviolability. So there are some very prominent examples of this. Jamaluddin al-Afghani or Asad Abadi, who's a very important figure in 19th century Islamic world, really, a kind of pan-Islamic thinker. He was one of these people who was dragged out violently from Shah Abdulazim close to Tehran. And so we have these examples of, in a sense, people being dragged out with violence, and this is always treated as if like it's a horrible violation of legality in some way, right? So in terms of the maneuvering of ordinary people, one of the things that, say, going to the shrines would allow for people to do would be to negotiate for a lighter sentence. Negotiate that they would say, leave a city, never return to a city, pay compensation for, say, a murder or what have you. And this would be in place of a ruling that had been made for, say, a death sentence. Right? So it created space in those ways. The other ways in which having multiple poles of jurisdiction was really important was that if you got a ruling from a local governor, you could petition the Shah and see if he would get involved and give you a different verdict. At the level of Islamic courts, you could get one ruling from one jurist, and if you didn't like that ruling or if it was negative towards you, you'd go to another jurist, and then they would issue another ruling, and then they would fight it out oftentimes. And so it became occasions for various Islamic jurists or Shia jurists to essentially play out their beefs with one another through these court cases. So what I would argue is that a lot of things that we perhaps in the 19th century look at as social mobilizations, right? These instances of, say, rebellion or protests against the state or what have you, actually have their origins in some of these legal cases and who have the authority to carry out punishments or try these cases.
Yeah, a really interesting example of that, I think, outside the shrine century question is the two brothers who are Baha'is or suspected of those sympathies, and it seems like just year after year after year, there's people are attacking them and trying to get them, people are going through different court systems or rough justice, like common people kinds of punishment, and then still they're just there, and it keeps coming up year after year. So it seems like that you're also arguing that they're using these different legal kind of jurisdictions and laws to defend themselves. But it goes on for a while, right? I mean, it's not a happy thing. It seems like they suffer a lot and are attacked and stuff. But there's, it's kind of an amazing story about how all sides are kind of using these different laws.
Yeah, absolutely. So one thing I would argue is that as bad as the 19th century was for Baha'is, for example, in terms of various cases of persecution and torture and all that sort of stuff, at least there were multiple poles of jurisdiction that they could employ and harness in a way that when you just have one legal system or a more unified state system, it becomes much more difficult to do that. Right? That the multiplicity of jurisdiction can, in some cases, allow you for some protections. Now, the other interesting thing about the case of the Baha'is in Qom, and it relates again to the public and private issue, is a lot of them presented themselves as Orthodox Muslims, but the people that would accuse them would say, no, they're secretly Baha'is. But if the public and private distinction is in place, then it shouldn't really matter, as long as they are presented as Orthodox and say we believe in the imams or go to the mosque and pray and what have you, it shouldn't be an issue. And so there are examples in those cases, and it's actually connected to an article that I'm working on now, where you see some figures, both within the government and within amongst the jurists, that are trying to get, for example, suspected Babis and Baha'is to curse the founders of their religion. And so this is an example of how, it's basically like an invasion of that privacy, of your private thoughts, that you have to then vocalize cursing in order to exculpate yourself. That's what's insisted. Now, there's no basis of this in Islamic jurisprudence, and yet, in some ways, I see it as one of the innovations of 19th century Qajar lawcraft, that they come up with this mechanism to overcome the idea of, well, how do you try heretics?
So there's a lot of violence in this story, especially the last few chapters, I think. Coming from all the actors, right? The state, the religious authorities, the lay people enacting rough justice, criminals, violent crime. I don't know if you want to talk at all about sort of how you've dealt with this in terms of were there considerations in terms of how you kind of construct your narratives around this, or and then maybe as a spin-off to this question, one of the really shocking things in the story is cannibalism, right? There's a period of a few years at least during the famine where it seems like every time a suspected criminal is captured and searched, he's got body parts on him, or she has toes of children in their bags, and so I'm wondering how you kind of think about this, both in terms of the narrative but also the sources, right? I mean, how you sort of differentiate between is this actually happening, or is it a moral panic, or
right.
I'm not up on my cannibalism studies, but
So maybe I'll start with that one and then move on to the violent. So there have been accounts and studies of the whole cannibalism in Qom, which were based primarily on British and European accounts, And so, if that's the only basis of information, you could argue that maybe this is sensationalism or what have you. But the source that I used was a local jurist from a pretty prominent family who gave a pretty detailed account of cannibalism in the home. And I tend to do think that it is reliable. There have been other studies of cannibalism in, say, medieval Egypt and what have you that I also sort of draw on. But in many ways, this is, I see it as kind of a breakdown of law and morality in many ways. And the interesting issue about it is then, well, how do people deal with this? So in some cases, there were formal trials or what have you, but in many other cases, it's what you were talking about. It's basically rough justice. People would discover people with body parts that they would be carrying around with them and realize that they had engaged in some sort of cannibalism, and then they would carry out their own rough justice on them, killing them before it even got to trial. So in many ways, I mean, there is a discussion of violence throughout all of these chapters, and really what I'm trying to do with that is I tend to agree that there is a way in which violence underwrites the law, right? That it in some ways it's crucial and at the core of what the law is. And so what's also fascinating about this is that a claim to carry out violence is often a claim to also have authority over the law. And so what's interesting about this is that it's not a case of the state's monopoly on legitimate use of violence, but you have multiple actors claiming that they have a right over some portion of the law, including ordinary subjects. So one of the examples that I give are the qisas cases, or cases of legal retribution involving women. Typically in Islamic history, qisas cases, the punishments are either carried out by state executioners, and we have plenty of examples of that in the book as well, or the family members of the aggrieved party, of the heirs of the person that was murdered in intentional homicide. But what I found is there was at least 4 cases of women in Qajar Iran carrying out qisas by their own hands. So this is actually even different than what the anthropologist Arzu Osmanlı looks at. She looks at how, for example, women in families often make the decision over whether or not someone is executed or not in contemporary Iran. Well, what I would argue is that there were periods in the 19th century where women felt a sense, and it's kind of perhaps strange to think about it in this way, empowered legally to carry out qisas by their own hands.
And there seems to be a sort of decline in that, or by the end of the century, right? Is that right? Women actually carrying out these kinds of violent punishments.
Yeah. So ironically, just as you have women's schools, women movements emerging, all of those things that we associate with modernization and women's autonomy, this form of legal autonomy is disappearing.
Yeah.
So.
Well, it doesn't really go with the domestic bourgeois.
Yeah, exactly. Yeah.
I don't know what time we're at.
1:20. 10 more minutes? 10 more minutes? If not, we can open it up. We can also open it up sooner.
I mean, yeah, maybe just, you mentioned near the end, I think it's near the end, probably in the epilogue, the constitutionalist movement, right, or movements of the late 19th, early 20th centuries. And I think you're making well, I'll give you 2 possible questions.
No.
Your choice. So I think you're making a different argument than other scholars about sort of the relation between law and reform, or law and politics in Iran, or, in this constitutionalist period. And, I'm personally interested in this because I'm, again, working on it kind of myself. So I wonder if you want to say any more about that. And, or, to jump forward to 1979, you refer to an abiding paradox of the Islamic Revolution. Right, had it predominantly, I'm quoting here, I think, had it predominantly Shia Iran shift from seeing religiously sanctioned violence of fixed mandatory punishments and forbidding wrong commanding right as being solely the prerogative of the imams to something that the jurists could not only implement but codify and make state law. So I'm going to say something more either about constitutional revolution or the Islamic revolution in relation to your arguments.
Okay.
Gesture on the upper level.
Yeah. So maybe I'll start with the Islamic, or kind of deal more with the Islamic revolution. So I think typically the way that the role of the jurist has been narrated is kind of a 20th century history of modernization, of secularization, and of the ulama as essentially, in some ways, reacting against this secularization and sort of conceptualizing a more robust form of Shia jurisprudence, and Khomeini is really the linchpin of this in terms of the doctrinal revolution that allows for this. Part of what I found in my book is that this is a much more long-standing process. The doctrinal shifts that occur, I think, occur through figures, not only the ones that are typically discussed, like Ahmad Narawi, who played an important role in the 19th century in arguing that the jurists could act on the authority of the hidden imam in his absence, but also figures like Muhammad Baqir Shafii that I talk a lot about in the book, who argues that the hudud punishments could in fact be carried out, right? And this is all in contradiction to many Shia jurists who argue that in fact you could not have these fixed mandatory punishments carried out, and you could also not have commanding the good and forbidding the wrong carried out. That these were things that only the Shia imam could do and no one else, and only when he would return then you could have these things enacted. So what I kind of argue with respect to that is that yes, some of these doctrinal discussions were happening earlier, so that's one thing. And then secondly, there's a politics of the street, where there are accounts of jurists and other Islamic leaders doing things like forbidding wrong with violence, which again, according to doctrine, should not have occurred. So for me, the genealogy of something like what happens in terms of the Islamic criminal code later on goes back to these practices of the 19th century, that there was a sort of politics of the street and legality of the street that existed that informed processes that occurred later on.
Great. Okay, I think we'll open it up for questions or comments.
Maybe I'll start with the first question just to get people going. Farzin, thank you so much, both of you guys, for a great conversation. Thank you. I was wondering if you could, because there are a lot of graduate students here, talk a little bit about archival process and challenges of doing, I don't think this is on, of doing research in Iran, in the current circumstance, but also in general, because you've been able to circumvent them in amazing ways. So if you could talk a little bit about your archival process.
Yeah, thank you. So one of the things that I should say is that it's been very difficult for me to actually go to Iran to do research. So I've had to do all of my research outside of the country. And the way that I have, tried to tackle some of these issues is to rely on things like digital or digitized archives. The Majlis library for the longest time was readily available in Tehran, and they digitized an enormous amount of material that I was able to draw on. I already mentioned the Sazman Asnad and how crucial it was when it opened up for me to be able to use. And then I would say also what really helped is to have a network of research assistants and colleagues that could help collect materials, right? So I think that was another strategy that I approached, that I used in tackling that issue. I should also say that I would say in the Iranian historian circles, in Iran itself, there's a sort of divide. There are people that tend to be actual historians in ways that we would recognize them to be, and what have you. And then you have people that are more archivists and find incredible sources, and then what they'll do is they'll edit them and publish them. What I find strange is that the historians don't really use those sources in Iran, or very, very rarely. So I saw an opportunity to draw on these sources that were edited, essentially primary sources coming out of the Iranian archives, and then use those for my research. So that was another strategy that I employed. So I'll give you an example of this. There was this great edited volume where it was a bunch of sources that were collected having to do with treaties between Iran and various countries. Embedded within that, I found a penal code, and I was like, what is this penal code doing here? And I looked further into it. There was no discussion of what the source was. I looked further into it, and I realized that it was a translation of the 1851 Ottoman Penal Code into Persian that no one had really talked about. And so as I put together these, and I found other translations of Ottoman penal codes later in the century, what I realized is that even the people who would edit and look at these sources didn't know what they were looking at necessarily. And so having that kind of wider lens where you're trying to read comparatively, I think is really important, because oftentimes the assumption is this must be a French text that they're just translating into Persian. But one of the sub-arguments of the book is that, well, no, in fact, a lot of legal modernity came via the Ottoman Empire. Right? That it was translations of translations, or adaptations, I would argue, of adaptations. Right? The Ottoman Penal Code is not. The various Ottoman penal codes are sometimes modeled on, say, the French Napoleonic codes, but they're not direct translations. And the keywords that they use often draw on Islamic legal terminologies. And so Iranians who translated in the 19th century would use a lot of those terms and sometimes tweak it for the Iranian context as well. So this text, and the reason why it was very difficult to tell that it was an Ottoman penal code, is that, in the original Ottoman Penal Code, it would say, send all these cases for judicial review to Istanbul. And then in the translation it would say, send all these legal cases to Tehran for judicial review, right? So it was clearly being written to be adopted as a code. But you wouldn't necessarily know that until you look more carefully at the text. Yeah.
It's also, sorry, I'll just continue.
Yeah, sure.
While you guys come up with questions. It's also, I think about how the material that you can access from outside the digitization. I'm sure you're aware the Golestan big photo dump that happened 2 years ago is another moment where all of a sudden people got access to all this stuff, some of which, I've worked in that archive for a long time, and there was stuff that in the photo dump that I hadn't seen. Wow. But I also wonder about these materials out of their context, because when you do that research in Golestan, they come in the albums where they're contextualized in their local history. So these photos went together. They're part of the same package of photos that were taken even on the same day. Whereas with the kind of, global distribution of them, you lose that local context and how it was kept, like what was this document kept with. So
that's so. At least what I saw in the Salzman Asnad materials, they would essentially reproduce the folios that you would receive if you went into the archive. And they had pretty detailed, actually, notes about the contents of it. Sometimes, even no matter how detailed they were, it wouldn't get at the complexity of the material that was within it. Sometimes when I was looking at, for example, cases of prostitution, they wouldn't necessarily use terminology that would allow me to search for that, so I kind of had to read between the lines of what those keywords were, or to just look for anything having to do with like a city report. A city report was often actually a police report, and so that was the process by which I was able to figure out, okay, this is going to be a great source for me in looking at the types of issues that are germane. Yes.
I have a rather simple question, but something that I'm very curious about. And that is the title of the book.
Yes, yeah.
Which you also made a comment saying that the public-private doesn't really work the way we translate it in English. But I'm also thinking of the scenes as well, particularly in the context of what you two have discussed, which is mostly based on Islamic or Shia jurisprudence. Just say a little more in Persian, in archival material, in the sources you use. How do people talk about these ideas? or
Mm-hmm.
and if you can use Persian words.
Sure, yeah. So sometimes the terminology around sinfulness is something like gunah, right? But then for crimes, or another constellation of terms which I found.
And not jinayat, for instance.
Yes, not jinayat, or something like these other terms that we would associate with crime per se. And then sometimes they would use a term like amal khalaf shar, so an act against the Sharia, right? Or the terminology that would also be used, and I think this is very common in Ottoman sources as well, is you would use a term like amal qabi or amal shani, and so it's like an ugly act, or sort of these
But
kind
this is
of
something that
euphemisms.
you define as private.
For the amal khalaf al-shar, that would typically be a way to indicate that it was a public violation of Sharia. Yeah. While gunah or something like that would be more used for the private sin that would occur. But there would be a lot of terminology that they did something, the issue would be, so did they do it alani or did they do it khafi, or something like that?
But the Canterbury case that you two talk,
Yeah.
that's jinayat, right?
You mean like in terms of the
In
murder?
terms
or
of
what have you?
how,
Yeah. So the terminology again would be much more specific. The term, for example, for murder would be qat. So they wouldn't necessarily talk about it as jinayat per se. So even jinayat, for example, is not all that common in the 19th century as a terminology to talk about crime. So it's a lot of terminology that's actually unfamiliar to us in the 21st century or even 20th century. And a lot of these terms actually undergo incredible transformations. So one term that goes under a lot of transformation is siyasat, and I talk a lot about that. So siyasat, to our contemporary ears, it just means politics. But in the 19th century, it had the connotation of capital punishment, execution. It also had the connotation of any kind of government punishment, so to distinguish it from Sharia punishments. So there's a way in which, for me, what that signals.
Question that ties into what they're
what that signals is that there's a direct relationship between politics and violence, and that it's there in the terminology, right? It's there in the keywords of 19th century, and it goes back to at least the time of Nizam al-Mulk, and we see it in Ottoman context used in very similar types of ways. So there's a way in which these terms go under major transformations. Another one is hukumat. We tend to think of it as government, but hukumat al-shaf or hukumat al-orf actually meant government courts or Sharia courts. So governance also had this legal connotation, and that legal connotation gets dropped in the 20th century. So I think there's very important terminological shifts that occur, and it's kind of perhaps the amnesia over these terms that kind of cloud our understanding of governance and law.
But do we also see an evolution of public and private, or whatever?
So what I would argue is that, for example, post-Islamic revolution, one of the things that we've seen is more of a collapse between the two, right? The state is much more interventionist in trying to figure out what people are doing in the domicile, right? That's one example. These raids of parties, underground parties that would occur in Iran, technically under Islamic jurisprudence, they should be allowed to do that because it's within the domicile and it's protected. Or you could also think of these inspections of cars, right? How does that fall in? In some ways, it's a private sphere, and yet there's ways in which you're checking to see if people have drank alcohol, if they're have been to some sort of party, if there are people that are non-mahram, unrelated individuals from the opposite gender, what have you. So that's also all these indications of how things have been collapsed. Even the forms of evidence that are used against people in trials today in Iran don't really uphold the standard that we see, say, in Islamic jurisprudence. It's oftentimes on very flimsy grounds that would be a violation of this privacy principle. So in many ways, I think these debates are very much alive and inform how the Islamic Republic carries out its own legal system.
Another one you talk about is Batin and Baha, right?
Yes.
Especially for the ideas, like if the
Mhm.
commitment was with the Baha'is, right?
Yeah,
The
yeah.
ideas are Batin, if they're internal, they're not, theoretically not legally subject to.
To punishment, yeah, and that's why I kind of gestured to that new project that I'm doing, where you basically have attempts to make people curse or disassociate from these ideas. It's an attempt to bring from the private to the public in ways that don't necessarily adhere to necessarily Sharia norms, and it's the beginning of kind of new innovations. Legal innovations to deal with the issue of criminal thoughts, criminal actions. And what I would argue is that this continues. I mean, in some ways, ways in which, say, political dissidents in the Pahlavi era had to disassociate and from their political affiliations to be allowed to go mainstream and be innocent. Or in the Islamic Republic today, how people have to kind of disavow their affiliations and connections to protests and what have you. That's all part of the same process.
Yeah,
Sorry, just a question.
Oh, by all means, by all means. Apologies.
Thank you. I was really struck by the part where you were discussing the sanctuaries. And, just some of the parallels I think all of us in the audience perhaps feel in thinking about places within our society where a certain groups of people are shielded from the law and the kind of crime that can come of that, and we see that there's obviously differences, but like with the Epstein situation and the way the state was shielding so much of the criminal activity that the ruling class was taking up. And so it helps, I think, clarify this understanding of what is and what isn't legal, really serving, the ruling class in a given situation. So I'm curious if the certain people who were shielded in the sanctuaries, what kind of class dynamics were present there? Were state officials or ruling class members of Qajar Iran more protected than, say, a peasant or something like that?
That's a good question. I would say that it was typically thought of as holding true, irrespective of whether you were an elite or say someone of a lower status. There were higher status people that took sanctuary as well, but so what would often happen, for example, if you were a disgraced, you would take sanctuary at the shrine, and you knew that the Shah or his whatever partisans would end up taking all of your possessions, and the next thing that might happen is that you might be killed. And so typically this was an attempt to negotiate more leniency, or to let the Shah cool down and then figure something out. I think the taboo about shedding blood or acting in violence in sanctuary was actually quite genuine, and the way you can think of it is almost as if you violated this taboo, it would bring down a curse on you, right? So I think it actually had a kind of psychic hold that is perhaps difficult for us to understand. So yeah, there is quite a bit of difference. That's not to say, and I didn't really go into this too much, but there were people who were protest and dissent. right? Because what do you do when you have the sepa kind of in its tentacles in all sorts of industries and economic and social and economic, realms, and they have their supporters, cultural realms, and they have these deep connections in various pockets of society, right? How do you then mobilize against that? And so that's not an easy story that you can reduce to centralization versus decentralization, but it's about the mechanisms of, I think, the way in which the state socially embeds itself. And so what I see in the Qajar period is the state is quite savvy at being able to do this. Not on a scale that we can see today, but it still has the kernel of those ideas already there.
I have a slight question. I was wondering if you have done any comparison with Azerbaijan. I cannot recall when that border was created there. And Russia, the Britons are Brits, they've come up a couple of times, but I believe Russia also had quite a presence in northern Iran at one point, and possibly still does. So I was just wondering if you've done any comparison with Sharia interpretation between the two countries. Of course, this would be a little bit more modern, but what kind of disparity might you find between the two? So.
Yeah, I mean, I haven't. I worked on connections. It depends what you mean, like the province of Azerbaijan versus the country, right? And of course, they were all one broader area until the sort of early 19th century. Probably into the 20th century, obviously, you have communist. USSR establishing its own legal system, so it becomes something very different, while Iran has a very different trajectory in the 20th century. Most of my comparisons were to the Ottoman Empire when I looked at connections and comparisons in the 19th century, but I also drew on, for example, some of the scholarship, there's not a ton, on Mughal India, because it's another example of a Persianate society. So one of the things that I found, which was quite interesting, is that the Emperor Akbar in the late 16th century had an administrative manual, and it's the same terminology in Persian, Dasturul Amal, where he says all capital punishments have to be sent from the provinces to the capital for final review by the Emperor Akbar, right? So a kind of curbing of the power of the governors. And Nasruddin Shah issues a very similar farman in the early 1870s, saying that all capital punishments have to be sent for final review to Nasruddin Shah, or to the Shah. Of course, again, there's the ideal, and then what happens on the ground is that they often carry out the executions, and the Shah isn't really able to do a whole lot about it. And that's why I think we have to take jurisdiction very seriously in Iran and understand how it's a give and take. It's not as if the Shah holds all the cards. There's a constant process of negotiation between various juridical sovereignties.
Yeah.
If there's one more question, we have time for that, and then we'll wrap it up.
I just wanted to know if you come across some like tribal related crimes in those archives, and if they were either like in courts or like just domestically within their own tribe.
That's a good question. So I focused on urban context, but one of the things that's very important is that oftentimes the urban courts drew cases from the environs of the city into the city. I guess in terms of tribes, the one example that really stands out is you have a lot of settled or semi-settled nomadic populations in cities like Esfahan. So there are quite a few Bakhtiaris and Lors that are concentrated in particular neighborhoods like Lonbong in places like Esfahan. And so there is an attempt by the state to crack down not only on those that are, there's an example of one Bakhtiari figure who essentially claims a type of local sovereignty in Esfahan, starting in his neighborhood, and he's almost making like a claim to semi-kingship. And I used Charles Tilley's idea of looking at, gangsterism and state making on a spectrum as playing out, where we see him as an example of someone who starts off looking like a criminal, but you can see the the germs of how states are actually formed. If you look at the early Qajars, they were also considered to be upstarts and criminals and what have you, and then they established a state, and I think that's the genesis of most states, right? So again, that relationship between violence and state is there. so yeah, yeah, leave it right there, I guess.
Most states are criminal. Thank you so much. So yeah, before we end, I just want to say one reminder that our last event, if you're interested in carceral systems, is also on prisons, on mass prison and its architectural history. So please join us on April 30th. And other than that, please join me in thanking our two guest speakers. There's still some food and snacks, so feel free to stick around and chat for the next day.
Thank you so much.
Thank you.
Thank you. Thank you so much.
Thank you so much. I have a big fan of